Fantastic. In which case, I should just ever so quickly stop sharing. So, hello everybody. Nice to see so many people on the call, which is great. I'm really pleased that we can host this session actually for Defra. We've got colleagues from Defra, from Tim, Jane, Katie, and Anna, who are all going to be sort of presenting different bits as we go through the day, and also Graham Kerr as well from Natural England, to give you a sense of their thinking actually regarding the responsible bodies role and sort of coming on. So there's lots of people on the call today, which is great. We've got a lot of high interest, if you like, in the session. So we are taking questions through Slido, so do put your questions in through that. We've got about 2 hours down for the session, whether we'll need all that or not, but there's a nice opportunity to ask questions. So do please log on to the Slido bit function to be able to put those questions in. Obviously, you would have all seen the launch last week. That week seems like it's flown by as well, to be quite honest. So regarding applying to become a responsible body. So part of today will be about sort of introducing the idea of conservation covenants, as well as also sort of going through that process as well of how those bodies, how the responsible bodies are going to be judged, if you like, in that process going forward. So lots of great opportunities to ask some questions, get some clarity, get some information. So in that case, without further ado, I'll kind of put you into presentation and get Tim to sort of start us off, if you like. So just Tim, so over to you, I think.
Thanks very much, Steve, and thanks to PAS for helping us organise the event. As ever, really helpful to have you guys supporting us. Thanks also for everybody attending. It is a good turnout with lots of organisations, so just what we were hoping to do, really. I'm Tim Andrews, so I'm the Defra lead for Conservation Covenants. So as Steve mentioned, you'll be hearing from my team today, but also from the BNG team in Defra and from Natural England. If we pop onto the next slide, what I'll do first of all is just cover off what we hope to achieve today. We're going to try and make sure you leave today with a better understanding of why we've introduced conservation covenants, what conservation covenants are, and how they'll be used in practice. We're also going to cover what the role of responsible bodies are in implementing conservation covenants. So we'll cover some of the specifics of what responsible bodies need to do. And Jane will also cover the criteria for selection of responsible bodies, which were published last week, as Steve mentioned, and also take you through a little bit of background on how you can apply to become a responsible body. And one of the aims for us today is to try and establish how many of your organisations are likely to apply, either in the longer term or the medium term, but particularly if you're thinking of applying in the next few months. And as Steve said, Natural England, Graham Kerr would also be just presenting an NE view of becoming a responsible body, and we anticipate NE will probably apply quite quickly. Next slide, please, Steve. So why have we got conservation covenants? It's quite a long history, and although I wasn't working on it then, the Law Commission in 2014, I think, first highlighted that there was a bit of a gap in terms of the way that we could take action to secure conservation on private land. There are ways you can do it now, but these tend to be a little bit complex and costly and sometimes quite slow. So one way that can be done is through designation. So a land can be designated a triple SI, or what used to be called a European site. That tends to happen when the land's of a particularly high value. So there's lots of opportunities where the land isn't of that high biodiversity or heritage value, where it might be useful to secure some conservation action. It's also slow. Government tends to take a while to designate habitats to become triple SIs or European sites. I'm just pausing, Steve, because someone's saying they can't see the slide, so I just want to pause and make sure people can. Is it just, I think it's Angus, is it just see? Okay, it looks like, Angus, it's just you, so apologies. We'll press on and hopefully it's at your end. So yeah, designation of protected sites is one way that we can secure action on private land. Also through property law, but there's some problems with property law in that you can't really assign positive obligations on landowners through property law. So a slight gap in the framework there. And landowners could form contracts that binds them to carry out certain actions on land, but that doesn't then bind future landowners. So this was all identified by the Law Commission. Subsequently, under the Environment Act, we introduced conservation covenants. Something that the Law Commission I don't think was or it wasn't on their radar is that recently there are lots of new opportunities around green markets, so ecosystem service provision, habitat banking, opportunities around tourism, and covenants are likely to be a useful tool to secure action on private land in those circumstances. We'll touch on that a bit later as well. Next slide, please. So what is a conservation covenant? Well, it's a tool. So it's an intervention from government that isn't perhaps like BNG or NNRS, where there's a lot of prescription. Really, it's just a new tool. It's pretty versatile. We're not very prescriptive about where and how they will be used. The key thing is that it will secure action in the long term. They're voluntary in nature, so no one will be compelled to enter into an agreement. That's something sometimes people raise some concerns about. But you don't have to. And likewise, if you're a responsible body and your approach to enter into a covenant, you're not obliged to. They are legally binding, so you can find yourself in court if you do not comply with the agreement that you've signed. They're private in nature. And what they must do is deliver for the public good and specifically deliver conservation for natural heritage features of land. So that's a specific purpose. And to address some of those shortcomings I mentioned in the previous slide, they can last in perpetuity. In practice, I think most will probably have an end date. Legal agreements that last in perpetuity can cause problems, and I'm thinking of sort of chance of repair liabilities. So we would probably expect most of them will have an end date. But if they don't specify that, then they last in perpetuity. And of course, the key thing, as I mentioned, is that new landowners are subject to those obligations, so they're passed on to future landowners. And again, to address the sort of gap I mentioned in the previous slide, they can contain positive and negative obligations. So that would be things that landowner must do or must not do on the land. And for the responsible body, it's things that they must do. Next slide, please, Steve. So where would they be used? Well, it's going to be a pretty diverse bag of uses, we think. And one of the questions we've been asked relatively frequently is, will government be issuing a standard template for agreements? And it's simply not possible to do that because of the diverse nature of covenants. They're going to be used in so many different ways that a one-size-fits-all template won't work. Probably as they become more used, then we anticipate that legal firms or other organisations might start to share templates, which other responsible bodies and landowners might pick up on. Where they'll be used, well, you're probably familiar that they're going to be used for biodiversity net gain, for off-site biodiversity net gain, and Katie will pick up on that. And back in their early thinking, in where they're used across the world, really, these kind of covenants, it's often for altruistic landowners. So it's someone who has some high value land or habitat or something with a heritage value that they want to secure for future generations. So they want to make sure beyond in their own life expectancy that habitat is secured. And they are also used sometimes for conservation organisations who don't want to go to the expense of purchasing land to establish a covenant with the landowner so that the land is managed in a particular way. That's a cheaper option. That's quite common across where covenants are used. At least that's quite a common application. And the last one, which I mentioned before, is ecosystem service provision and habitat banking. We think they'll be used to support those new green markets as they emerge. Next slide, please, Steve. So I'll hand over now to Katie Gowers, who will take you through a few slides around conservation covenants and biodiversity net gain. Thanks, Katie.
Thanks, Tim. And hello, everyone. So I'm Katie Gowers. I'm a senior policy advisor in Defra's B&G team, and I work on the register and how we're securing gain sites. The next slide, please, Steve. So I'm just going to give a brief summary of where conservation covenants fit in with B&G, and then I'm going to touch on why local authorities may want to apply to be a responsible body for biodiversity net gain. So biodiversity net gain sites need to be secured by either a planning obligation or a conservation covenant, and then registered before they can be used as off-site provision for B&G. Conservation covenants used for this process have additional requirements. So they'll need to last for 30 years from the completion of habitat creation works as set out in the Environment Act. They'll need obligations for habitat enhancement and the maintenance of that enhancement over the 30 years. And habitat enhancements will need to be made available to be allocated to one or more development. So conservation covenants or planning obligations are a prerequisite to registering on the Biodiversity Game Site Register. So a copy of this agreement will need to be submitted at registration. And Natural England, as the register operator, will be checking these agreements to ensure they meet certain eligibility criteria that will be setting out in secondary legislation. We'll be publishing guidance on securing biodiversity gain sites and what should be included in these legal agreements, and we'll include some guidance on considerations for responsible bodies and local planning authorities entering agreements for biodiversity net gain. Next slide, please. And then briefly to cover why local authorities might want to be responsible bodies for B&G. So planning obligations need to fall within the commitments set out in Section 106 of the Town and Country Planning Act, and they also need to meet the tests of the Community Infrastructure Levy, whereas conservation covenants do not have these same restrictions, so they're more flexible in application. They're also more flexible in terms of monetary contributions. So ancillary obligations in the covenant can set out how a responsible body is paid for services such as monitoring and expertise. And finally, they can be used as a route for securing local authority owned land as a biodiversity game site. So whereas a local authority cannot enter a Section 106 agreement with themselves, they could enter a conservation covenant as a landowner with another responsible body, which could be another designated local authority or organisation. And then I'll pass back to Tim for more information on the role of responsible bodies.
Thanks, Katie. Yeah, so what are responsible bodies going to be doing? Well, they're going to be, as one of the two parties to a conservation covenant, pretty integral. So they're going to be, it's going to be quite an important role. So they'll need to be able to make informed decisions about creating covenants and implementing them, and sort of underpinning informed, and Jane will touch on this, they need to have the expertise to be able to make those decisions. We talk sometimes as well about responsible bodies enforcing covenants. It's a word I'm slightly nervous about, because responsible bodies won't be granted additional powers, so powers of entry or anything like that. If they have those powers already, then fair enough. And some organisations who become responsible bodies may have powers, but under the Act, there's no new powers for responsible bodies. So when we talk about enforcement, what we're really talking about is working with the landowners to make sure that the covenant is being implemented, and that's through monitoring and inspection. And as a very last resort, because it's a legal agreement, ultimately responsible bodies, if they're unhappy with the implementation of the covenant and they can't resolve the issues, then they can go to court, and then the courts can issue an injunction to stop something happening, or an order to make something happen, or grant damages if part of the failure of the covenant is around the funding that was agreed. So it's a little bit cautious about saying enforcement. We see responsible bodies as working very closely with landowners, but they're not policing them or enforcing against them. Once they're designated, slightly unusually, responsible bodies for this sort of framework aren't going to be regulated by government, in the sense that government isn't going to have an awful lot of oversight of what responsible bodies do. The clue is in the title, I guess. Once designated, we're expecting responsible bodies to be able to carry out those functions for decades. So what we've done, and we'll come on to this when Jane looks at the criteria, is we've been very careful to set criteria that allow us a good deal of upfront assurance that responsible bodies will be able to do their functions. And you'll see we've actually developed a particular criteria that tries to ensure that. Next slide, please, Steve. So why become a responsible body? Well, we think probably a lot of the organisations that are likely to apply within their articles of association and within their sort of corporate strategies, they will be organisations that already deliver for the public good, but the likelihood is that becoming a responsible body will be to allow them to further deliver for the public good. So in some cases that will be a newish role for some organisations. The other key thing that responsible bodies and organisations might want to become a responsible body is the market opportunities. Responsible bodies can derive some income from being for carrying out their functions, and that although they're delivering for the public good and although they're delivering for conservation, there's absolutely no issue with them having a commercial interest in delivering covenants. And also to some degree, becoming a responsible body will help raise the profile of organisations. So that might be locally, that could be nationally, and in some cases where responsible bodies are dealing with covenants that cover very large areas of land, you know, even internationally. Next slide, please, Steve. So what else do responsible bodies have to do? Well, they must ensure that the covenant is there to deliver the public good and to protect, restore, enhance natural heritage features of land. So they have to deliver on the nature and heritage conservation benefits. And also, they need to make sure that landowners who are entering into covenants understand what the implications are. So they need to understand that these are potentially very long-term commitments. They also need to check that independent legal advice has been sought, and that's quite critical. If I look at the next bullet, covenants can't trump or undermine existing legal agreements or property agreements, so tenancies, rights of way. So the responsible body needs to work with the landowner and independent legal advice to check that the covenant doesn't do that. And two specific things on the face of the Act that responsible bodies must do: they have to register the covenant as a local land charge, and they have to submit an annual return to Defra. That annual return, I was mentioning there's sort of little sort of regulation or oversight of responsible bodies. The annual return is one thing that bodies must do, but it's quite light touch at the moment. All we're asking for the annual return is the number of covenants that the responsible body has entered into and the area that they cover. We have asked for a little bit of additional voluntary information on annual returns, but we're not mandating that. We do have provision under the Act if the sort of framework for responsible bodies and covenants isn't quite working as we expect, then we can ask for more information in an annual return. But at the moment, it's fairly light touch. Next slide, please, Steve. What else? There's a few other things we're expecting responsible bodies to do. So they're going to be charged with monitoring agreements. What the monitoring agreements are will be dependent on what's in the covenant. They could be fairly light touch, they could be very detailed. So they need to carry out surveys and regular inspections to look at what's happening with the conservation and heritage features covered by the covenant. They need to keep records of those to make sure that those monitoring and inspections are recorded and are available. And they might well need to generate maps of land under covenant. They also need to be thinking about, given the long-term nature of covenants, what happens when things change. So we'd expect responsible bodies to be able to think about contingency arrangements. And that could include in terms of management agreements and monitoring agreements, how they might need to evolve and adapt given what happens on the land. Next slide. I think there's one more, Steve, on responsible bodies, or is that it? No, that's it. So over to Graham from Natural England, who's going to talk a little bit about why Natural England wants to become a responsible body. Thanks, Graham.
Okay, thanks, Tim. I think it's next slide now, please. That's it. Thank you. I'm Graham Kerr. I lead on conservation covenants in Natural England. I'll start by welcoming Defra's announcement last Thursday and that we can now apply for responsible body status. Some of you may know that Natural England's board has already taken the decision that we wish to apply. We intend to do so soon, and we've already started to digest what we need to do to complete the application. We're wanting conservation covenants to be in our toolbox to help us to create more joined up space for nature. We also hope that many organisations here today and sort of within England will take the opportunity to apply. One of the things that we think is that the potential of conservation covenants is more likely to be realised when there's many responsible bodies rather than a few. We want to be one of many rather than sort of one of few. For the next few slides, I'm going to be picking on some of the points that have already been raised by Tim. And that's going to be my starting point. So I'm just going to draw out a few issues that responsible bodies might face or potential applicants might want to consider. And then I'm going to finish off with a few thoughts on what Natural England might do if it becomes a responsible body. Next slide, please, Steve. You probably recognise these points. What I'll say is that Natural England, we work with landowners to secure environmental outcomes. We seek to lower the risks and the costs to deliver conservation, and we're working towards leaving our environment in a better state for future generations. Now, joining up the points long-term, lower risks, future generations, what it makes me think is that conservation covenants will be used for sort of long-term, spanning multiple generations, delivering at lower risk than the alternatives that are available to us. Now, the challenge is likely to be in terms of how responsible bodies are going to manage cumulative risks and costs arising from lots and lots of conservation covenants, which have been either long-term or in perpetuity. It's a new area for most organizations. They don't have that experience. If you look at the financial declaration that's got to be signed in the application, I think that is very, very relevant. Now, I've worked on conservation covenants for quite a while and looked at experiences from around the world. And if you look at the American experience, what they've been saying is that their land trust, which is probably the nearest equivalent to a responsible body for them, they start with an acquisition phase, and then they move on to a management phase. So they actually reach a capacity. They start off and then they plateau, and it just sort of remains level. Some of them then amalgamate and become bigger that way. That's one way to sort of manage that sort of cumulative risk. There are other options. I think those other options may be limiting the duration of the agreement. Tim's already alluded to limiting, having the time frame specified for other reasons. It would also help with sort of capacity issues, or including break clauses within the conservation covenant agreement. Next slide, please. These are other points that you probably recognise. If I focus on the first two instances, in both of those, the responsible body is going to be reactive to an approach by a landowner. Natural England's already been approached by landowners seeking conservation covenants, and we're not a responsible body, but people out there think that conservation covenants already exist. In the second two instances, the responsible body is being proactive. They're approaching landowners to try and secure a specific agreement, something that it wants to do. So going back to the instances where the landowner approaches the responsible body needs to be able to respond to a letter saying, I want to apply for a conservation covenant. We've received those. And how it will have to decide how it's going to determine that type of application. For Natural England as a public body, we need to take all those decisions in a transparent and rational way. We need to be able to say yes and no to any proposal, and getting those decisions right is going to play a very important part in ensuring that conservation covenants don't exceed the our organizational capacity and capability. And again, that's one of the criteria that's within the application. Can we move on to the next slide, please? So this is my last slide. Just thought I'd say a little bit about what Natural England might do if appointed a responsible body. We are going to be pretty cautious. We've already started to develop some of the processes and procedures that we hope to use, but we want to test them before sort of rolling it out across the whole organization. We'll be using that sort of a limited number of conservation covenants, which we'll then evaluate, and the lessons learned from that evaluation will establish what our final procedures and processes are going to be. I anticipate that our first conservation covenants are likely to be aligned to our nature recovery strategy, and they will probably be drawn from a range of circumstances. Some examples would be focusing on the conserving habitats, delivering nature-based solutions, or be aligned to supporting outcomes of our designated sites, or perhaps to some of the schemes that we run. To finish, I just want to say that I think conservation covenants are a very really big opportunity for us to deliver nature recovery, which will benefit future generations, and that the opportunity can only be realised if there are responsible bodies working with landowners. Thank you. Jane?
Thank you, Graham. Yes, hello everyone. I'm Jane Widdowson, and I'm a Senior Policy Advisor within Defra, working on Tim's team on conservation covenants. And I'm just going to talk to you about the application process to become a responsible body. And the link on this slide would take you to a landing page for applications. So there you'll find links to the criteria for applying, which I will look at, the application form itself, and guidance on the application process. And the applications will be assessed against the published criteria. So we're asking applicants to provide evidence that they meet each criterion, which again, we'll go on to look at in a little more detail in a moment. But we'll aim to notify applicants of the outcome of their application within 12 weeks of receiving a completed application. Next slide, please. So who can apply to become a responsible body is actually set out in the Environment Act. So it can be a local authority, a public body or charity where at least some of its main purposes or functions relate to conservation, and then any other body other than a public body or charity where at least some of its main activities relate to conservation. So obviously that includes private sector organisations. The next slide, please. So there are 4 criteria which applicants will be assessed against, which I'll talk you through. But just to know, all this information can be found on the application form itself, including examples of evidence that applicants can provide against each element of the criteria. So the first criteria is eligibility, and applicants will need to provide evidence that their organisation has an operating base in the UK that will allow it to properly carry out its conservation covenant functions, which really means that the main activities to deliver conservation covenants and the people that will be delivering them must be located in the UK. And so just to give you an idea, an example of the evidence we'd be asking applicants to provide here would be a copy of a business rates bill. And then applicants must satisfy the Secretary of State that at least some of the organisation's main purposes, functions or activities, depending on the type of organisation, relate to conservation. But the Environment Act does set out that local authorities are exempt from this particular element of the criteria. But for other applicants, the evidence that could be provided here, for example, is details of conservation projects that the organisation has delivered, or referencing relevant sections of an annual report or charitable objects. And then moving on to the second criterion, which is financial security. So as part of the application process, we'll check that an organisation's financial situation is secure and that it has adequate internal fiscal and administrative control for the long-term financial viability that's needed as a responsible body. And as part of this, we may carry out due diligence checks using Spotlight, which is a Cabinet Office automated tool. So we'll be asking for details of the organisation's UK bank account, and also for applicants to provide the latest annual report or a credit rating report from 2 credit agencies. As I said, all of this is on the application form. And if an applicant is a newly formed organisation, then we'll ask for the last 3 full months of bank statements or a letter confirming that a UK bank account has been opened. And then as part of this criterion, we'll also ask an accountant, a finance director or equivalent within the organisation to sign a financial declaration on behalf of the organisation. And that declaration is set out on the application form itself. Next slide, please, Steve. So the third criterion is operational capacity and capability, which I think has already been touched on. But this really means that an organisation must have that capacity and capability to manage and enforce the types of covenants that it would expect to enter into if it was designated as a responsible body. So you can see there the list under heading 3. There are various elements to this criterion. I'll quickly run through them. So we ask for evidence of an organisation's relevant expertise, which could be, for example, previous experience of conservation projects, access to ecologists or agronomists, obviously for nature conservation, or the equivalent for heritage conservation. We ask for evidence of workforce structure and capacity to effectively deliver covenants. So examples here could be providing an organisational chart or articles of association. We ask for evidence to demonstrate the ability to plan and develop contingency measures. So, for example, a risk register, assessments or contingency arrangements used for previous projects. We ask for evidence of the ability to monitor compliance and take action to address any breaches of agreements. So again, applicants could provide the monitoring and compliance arrangements they've used for previous projects. We ask for evidence of or proposed processes for dispute resolution. So perhaps a dispute resolution plan, or evidence of access to an expert adjudicator or professional mediation or arbitration services. And as part of this, we'll ask for evidence of clear structures and governance that show that an organisation could report and escalate any issues and identify and address any conflicts of interest. So as an example, an organisation could provide existing policies and processes here. And then finally, on this element, we ask for evidence of an organisation's track record for environmental or heritage responsibility where that's available. So, for example, a summary of previous experience, referencing perhaps relevant sections of any project reports that can be provided with the application form. And the application form, this isn't noted on here, but as part of the track record, applicants need to provide details of any pending or unspent prosecutions or published civil sanctions that fall under environmental or heritage regulations, and that's within the last 5 years. And then any charities applying need to provide details of any charity commission inquiry within the last 3 years. This list does sound long, but all this information is on the application form itself. And the form does quite nicely guide you through what needs to be provided. And then finally, the fourth criterion, which Tim's already mentioned, is around this ongoing suitability, because if an organisation is successfully designated as a responsible body, it must continue to meet those first 3 criteria for being a responsible body. So if the organisation's circumstances change and it no longer meets one or more of the other criteria, then it must notify Defra as soon as possible. And so for this criteria, for that upfront assurance that Tim mentioned, we ask for a signed declaration from a director or equivalent confirming that the organisation really understands the roles and responsibilities it would be taking on as a responsible body, and commits to informing the Secretary of State if any change in circumstance may impact on its ability to deliver on any of its covenants. So that can be any relevant change in circumstance, but we've given some examples in the declaration that you can see some of listed here. So it includes things like any disputes with landowners about the delivery of a covenant that it or the courts are unable to resolve, any new criminal prosecution, civil sanction, charity commission inquiry, fraud or insolvency proceeding, any conflicts of interest, that's new conflicts of interest that haven't already been declared, any significant changes in the financial situation, any changes in the expertise required to deliver covenants, or changes in the organisation's main purpose, functions or activities so that they no longer relate to conservation. Next slide, please. So that was a bit of a gallop through the 4 criteria, but we will be available to support applications via our Conservation Covenants mailbox, and I'll share that address in a moment. And I know these slides are being shared afterwards, so you'll have a copy of that. But we will do an initial check of any application when it's received, just to make sure all the relevant sections have been completed and the necessary supporting evidence has been provided. So we will contact applicants if further information will be needed right at the beginning. We are then aiming to inform applicants of the outcome of their application within 12 weeks of receiving that completed application. So that's after we've checked back and made sure that the application's complete. And it is a rolling application process, so there's no deadline as such. Next slide, please. So that's the end of our presentation. Just to say a huge thank you for coming along today. We really do appreciate it. And we're going to move on to the Q&A in a second. But for any questions that you might have following the session, you can email us. So for any questions on conservation covenants, please use that first conservation covenant mailbox address that's on the right. And then for any questions on biodiversity net gain, please use the second address. And this is just, it would be really helpful if you could use the relevant mailbox, please, just so that we're separate teams. So just so that we're not duplicating time spent on responding to the same inquiry. So really big thank you again, and I'll pass back to you there, Steve.
Brilliant, thanks Jane, and Katie and Graham and Tim there. So I'll just get off that, hopefully. Yeah, that's great. Just trying to pull up some of the, I saw some of the questions coming in on Slido, and lots of things kind of flying around, which is great. A few things I think were probably answered within the within some of the presentation, but no harm, I think, in just sort of reiterating some of the points that have gone there. So I mean principally, I think probably the first one, probably Tim, the sort of the benefits of this, of conservation covenants and being a responsible body in relation to the Section 106 process that they have presently. So just sort of to, you know, to give some help, if you like, on authorities to think about why they want to sort of go into this, if you like, rather than being reliant on the processes that they have presently.
Yeah, I'll invite Katie to comment on the 106 element. I mean, I think broadly, just to be clear, there's no obligation on any organisation to become a responsible body, including local authorities. It's not sort of being prescribed as a specific role. Perhaps I think there was a question around LNRS's responsible authorities. Excuse me, it's not responsible authorities, is it? Anyway, so it's not a prescription. So government isn't saying to local authorities or any organisation become a responsible body. So each organisation can look at what might be the benefits and the disbenefits and decide if the overhead of becoming one is too much. Then obviously they'll choose not to. But particularly in terms of 106, Katie, are you happy to field that one?
Yeah, sure. So I hopefully covered a bit of this, but I think conservation covenants are just a bit more flexible than Section 106s in regard to not having to meet the test that I set out and in terms of monetary contributions. So you're not restricted in only being able to get monitoring payments. You can get payments for more services you can offer. So there's maybe a bit more of a commercial element to being a responsible body for a conservation covenant. So yeah, hopefully that would be a benefit. But as Tim said, it's completely up to you whether you do want to apply and whether you think the benefits are worth it.
Yeah, and it's designated authorities, isn't it? Sorry, on LNRSs, which are designated. Responsible bodies are not going to be designated. They're going to apply and be selected if they meet the criteria. So optional.
Okay, thank you, Tim. Thank you, Katie. There's a question regarding the secondary regs that are going to be required, because obviously we're waiting for quite a lot of stuff to come out in kind of both BNG world and wider planning world as well at the moment, to be quite honest. But do you have any understanding about the timetable for the secondary legislation coming out? Just because I think authorities are going to be thinking about whether they're going to want to put an application in straight away, I suppose.
Yeah, I'm not sure we have a firm timeline on the secondary regulations. I'm afraid we are working on some policy statements that will be available and hopefully provide some information. And I think that question asked about guidance as well. So I'm presuming that's the guidance I mentioned on securing gains. And that is drafted, awaiting clearance, and hopefully will be out very soon. So again, sorry, no set deadline, but that one's definitely being prioritised for the quickest release we can.
Thanks, Katie. Great. Just to go through some others here. Yeah, have you had any thought about actually just trying to build in a sort of not a template approach, but some of the more regular things that are going to have to happen for regarding a conservation covenant, if you like, or regarding the BNG work to be able to do? Because we recognise it's going to be quite flexible about what this is going to cover, but actually almost like standardising what could be.
Yeah, we did. Sorry, Tim.
No, you go, you jump.
We did look at a template for BNG, but we had some advice that responsible bodies would want their own specific things included based on their own legal advice. So we're not pursuing that, but we are producing guidance which will detail exactly what to include in these legal agreements for BNG, which will hopefully help the conservation covenants get built. Obviously, if there's a lot of feedback for a template, then we can try and look at developing that as well. But yeah, that was just based on previous advice.
And I think outside of the BNG world, we don't intend to provide any further templates or specific guidance on specific contents for covenants, simply because there will be a huge sort of variety of covenants, and there'll be private agreements in nature. So we don't see our role as trying to prescribe a given approach within a covenant. It will depend very much on the responsible body and the landowner developing ones that fit the purpose that they want to achieve.
Can I also say that Natural England's actually started to look at developing a template for its own uses? So we started drafting that, and we discovered that it's very difficult to get a single template to cover all the things that we might want to use it for. So our initial conservation covenants are very likely to be bespoke agreements, and we'll see how they develop and see if we can get a template from that subsequently.
Thanks, Graham. That's really helpful, actually. I think you're practically probably further into this, if you like, than many others. So that's all kind of really useful learning. There was a question raised actually just about how you're actually going to be able to control the ability for an organisation to be able to well, especially for local authorities, I suppose, to be able to enter into a conservation covenant in their own area, if you like, with themselves, to be able to go through. So whether this needs to be done as a local authority, as a landowner, whether they need to get a secondary organisation to be able to do that, or are their arm-length bodies going to be able to do that through it?
I think the short answer is you can't enter into an agreement with yourselves. So if you're the landowner and a responsible body, you can't draw up your own agreement. So you'd need to find, if you're the landowner, another responsible body. So you could look to another local authority or anyone who's become a responsible body, but you can't have an agreement with yourself.
Yeah, okay. And so just to play that through, if a local authority's got a housing delivery body, an arm's length for a housing delivery body, could they do it as a partner organisation, or would it have to be completely separate?
They'd have to be designated as a responsible body. If that's what you mean, Steve, I'm not sure I understand the question. They have, so the only people who can enter into a covenant are landowners and responsible bodies. So there's no sort of third party or arm's length body or other public authority. If they haven't been designated, they can't enter into a covenant.
Yeah. Okay. Yeah. I suppose it's that ability to go through that process. But it seems to me most of the time, local authorities looking at this as landowners are going to want to be partnering up with another local authority or other thing who are registered as a responsible body, potentially. Yeah.
Possibly, yeah. I mean, I wouldn't preclude. You could enter in if an ENGO, it'd become a responsible body, a wildlife trust. They could still act as a responsible body. There's nothing preventing that either. But it just makes some sense that local authorities will sort of work collectively in that way, but it doesn't have to be. Yeah.
Okay. Great. Thank you. As someone's posted a question up here, it's sort of actually, have you had any thought about why an authority would not want to think about becoming a responsible body? Sort of what characteristics might drive it from that end?
No, it's a good question. I mean, there's overhead in the application, and there's maybe overhead in delivering them. But then there may be some commercial opportunities as well. There may be some income. So again, it'll be for each organisation, be it a local authority, an ENGO, or an ALB, to think through that and draw their own conclusion about whether the effort is worth, whether the benefits outweigh the costs, really. Anybody else? Any reasons why we if we were a local authority, we wouldn't be interested? I'm just trying to think. No, evidently not, Steve. So
evidently not. That's great. That's great.
Yeah.
Thanks. I haven't had a look at poll data, and obviously everyone, just to say, there is the polls up there to some of that is about trying to get a bit of a sense about where the interest lies, etc. So as I say, I haven't had a quick look over, but just as a case, just what happens if there's insufficient responsible bodies registered by the time the system is working and goes live, because that timeline is quite tight, particularly around BNG at the moment.
Shall I come in there?
Yeah, please do, Katie.
Essentially, we need to rely more heavily on planning obligations if there weren't enough responsible bodies, because they're the only two means for offsite providers. But we do know there is quite a lot of market readiness, and we're obviously hopeful there'll be a lot of interest in responsible bodies, and therefore, yeah, it'll all fall beautifully into place. But if not, then yeah, we'll just have to rely on planning obligations a little bit more heavily in the interim.
Okay, thank you, Katie. Yeah,
Dave, can I come back?
Sorry, Graham. Yeah,
can I come back on the previous point? I tried to speak, but I switched my mic off.
So I couldn't see your lips moving. Sorry.
Why a local authority might not want to become one. Once you become a responsible body, you could be approached by anyone for a conservation covenant. And it was my point, you have to have the ability to say yes or no. You don't want to be in a situation where you have to use resources to say no all the time. That would be a cost which you probably don't want.
Although it's also true to say, Graham, that there is no obligation on a responsible body. So
that's right, yes. So you can say no. It's perfectly acceptable, but you have to do it. Yes.
But I guess what I'm pointing at is that the organisation couldn't then be challenged for saying no. They don't have any sort of legal duty to deliver a number of covenants or to explain why they don't want to. They can just say no.
Yeah. I mean, just on that balance of expense and income, or potential income, shall we say, or so much. Do you think that most local authorities probably will want to become responsible bodies in this, in one way or another? Or there'll be the positives you think are going to outweigh the financial negatives, shall we say, in setting it up over time?
I mean, I think the answer is yes. We hope so. Yes, that's what our hope is.
Okay. There was a question raised as well about is there going to be a a published list of responsible bodies and how it's going to be kept up to date and managed?
Yeah, it's an
Yeah.
obligation on the act. Sorry, Jane, you go.
Sorry.
You go, Jane.
Just to save you answering every question, Tim. Yes, as Tim was just saying, it's an obligation on the Act that we need to publish a list of responsible bodies. So yes, once the first bodies are designated and then ongoing after that with each designation, there'll be published list on gov.uk, and that will be the name of the responsible body, probably the where they're based, and what their expertise is. So whether that's nature-based or heritage-related.
So the idea being, thanks, Jane, yeah, that people can look at that list and pick responsible bodies that have the right kind of expertise to deliver the covenants that they're interested in.
Okay, thank you. And do you is it going to be Defra's role in maintaining that list?
Yeah.
Great. Let's see what else we've got here. Is the expectation that conservation covenants are going to be made publicly available? As
short answer there, Steve, is they're private, so no. In some circumstances, the signatories to them may choose to make them public, but there's no obligation for them to publish them. They are private agreements.
Okay. Okay, thank you. Yeah, regarding the role of the responsible body, what legal obligation are you going to have to report the monitoring to the local authority?
No, others will correct me if I'm wrong, but no obligation, no legal obligation to report monitoring to the local authority. No.
So how is the monitoring and reporting of the conservation covenant going forward?
For BNG, is it?
Yeah.
Is that what? Okay. I'm hoping Katie can fill that.
Yeah, so for planning obligations, it's obviously monitoring and enforcing to the LPA, but for conservation covenants, it's to the responsible body, and then they're reporting on their covenants back to the Secretary of State. But there's actually no real overlap between the LPA and the responsible body, so the responsible body doesn't have to report to the LPA as well.
Right, so it all gets reported into the Secretary of State going through, yeah, okay, that's great. Yeah, thank you. So then the recognition of the monitoring is through that side.
Yeah, the responsible body is effectively carrying out the role that the LPA does in a planning obligation for a covenant.
Yeah, brilliant. Okay, thank you. The question here: who will enforce things when they go wrong? Since it's a good, nice little short question for you, if you like.
So if things go badly wrong, the recourse for either the landowner or the responsible body, if either one of them is not fulfilling its obligation to the courts. But if we just reflect on some of the criteria that Jane was describing, what we want to be able to see from responsible bodies is the ability to resolve disputes and some track record of doing that. So ideally, things don't go to court, but ultimately that's where they'll end up if things can't be resolved between the two signatories to a covenant. And then the court can issue an injunction to stop something happening. It can issue an order to make something happen, or it can award damages. So the three things courts can generally do. But we do want that to be very much a last resort for responsible bodies and landowners. And we'd expect a responsible body to resolve disputes in 99% of cases.
Okay. Yeah, thank you. So can we just, there's a question asked just about actually how you expect responsible bodies to actually derive income, if you like, playing through the process. So I'm sure that's going to be one of the reasons why people are seriously thinking about it, particularly on the local authority side.
Yeah, I mean, maybe Katie could do this through BNG, although essentially I think that they'll be paid by the developer to deliver the covenant. But then there are also, for sort of ecosystem services provision, there could be a model where there's a sort of three-way arrangement whereby, or for habitat banking, whereby a landowner is developing a habitat that delivers ecosystem service provisions. The responsible body is making sure it's being delivered in the long term, and then in theory, investors may well be, third-party investors may be interested in funding some of that work for a return. So when the ecosystem services are sold, the responsible body makes some money, the landowner makes some money, and investors make some money. So it's those new green markets. And we think some of the commercial opportunities around that could become quite significant. And the same with habitat banking. So a developer may buy land to deliver its offsite BNG, work with the responsible bodies to secure the land, but it develops more than it needs to deliver its own obligations and sells the rest. So again, the responsible body, in a simple sense, would have a cut of that arrangement and make some money. Is that about right, Katie, for BNG, or have I oversimplified?
Yeah. No, essentially, yeah, it's a big income stream potentially for landowners, and in order to secure their land, they will need a responsible body or a local planning authority. So being able to pay a responsible body obviously makes a lot of sense. So you can use the ancillary obligations in the covenant to secure those payments.
Okay, brilliant, thank you. I think I kind of know the answer to this, but I'm going to ask it anyway. But so what if there is no responsible body in an area for someone to enter into a covenant with?
Sorry, Katie, you're going to speak. I'll let you go.
That's all right. I think this was framed if a local planning authority couldn't enter a conservation covenant, and that is a potential blocker that we have considered as a risk, because obviously if we don't have enough responsible bodies, as I said, you can't enter a Section 106 with yourself. There are some complex workarounds. So if you're not a unitary authority, you can potentially enter with your counterpart. But yeah, appreciate I don't have a solid answer to this. It is a risk that we are aware of, and yeah, working to make sure we resolve that. And hopefully, again, we'll have lots of responsible bodies.
And you know, hopefully, if there are organisations such as Natural England who are playing in this space, there's hopefully that one organisation at least within that would cover an area that potentially could do it. So no pressure, Graham. Yeah.
You're on mute, Graham, if you are speaking. Or are you not speaking? Oh, you are.
I was on mute. I was smiling at that. One of the things that Natural England would have to consider before getting into sort of this space with biodiversity net gain is how it would align with our responsibility as the register operator. We've already recognised there's sort of an issue around perceived conflict of interest.
Yeah, because the roles that you play as the wider part of this as well. Yeah, absolutely. Can understand that. I'm just kind of quickly having a look through, see if there's any others, and if there's any others in the team who kind of feel that there's any kind of key questions that you think you'd really be key to answer, feel free just to highlight them up as well as you, if you see them.
I'll clarify there's one at the top of the slide actually about how can developers be expected to enter into legal agreements to register their offsite solution. And I just want to be clear that the legal agreements are landowners and responsible bodies or LPAs in order to secure offsite land rather than developers. So they might have separate contractual agreements with developers about when they're buying their units, but these could be conditional on game plan approval. So yeah, just to be clear that when we're talking about the conservation covenants and planning obligations, that's with the landowner, obviously, and then the developer comes in with a separate agreement with the landowner in terms of purchasing units.
Yeah, thank you. So there's a question here regarding the next one from the top, actually, which is just regarding the enforcement requirement, I suppose, from this. And I know you kind of mentioned some of this, I think, within the presentation about it's not seen as an enforcement role, I suppose. I think Tim, you kind of covered some of that.
Yeah, I mean, enforcement just means making sure the other party to the agreement does what they've said they're going to do, but there aren't particular additional powers that responsible bodies will be afforded to do that. The ultimate recourse is the courts, but what we're trying to do is to make sure the responsible bodies we appoint are all well equipped to resolve disputes and to monitor and to work with landowners in a very positive way. So we're not seeing them as a policing organisation. We're seeing them as somebody who agrees to secure conservation on land in a very sort of positive way. So they don't have enforcement powers. Yeah.
Thank you. Can I ask a quick question, probably to Jane, actually? You said in the presentation you're looking at a 12-week turnaround on the applications to come in. Is that set by how long you actually think it will take to actually turn them around, if that makes sense? Or are you expecting them to come around a lot quicker through the process than the 12 weeks?
Well, if we say up to 12 weeks, obviously we've not done this before. That's one point. We don't, we're hoping we might get a little bit of a sense of this today. We don't know how many applications we're going to get. So there are some unknowns. And yeah, we have a very clearly defined internal process set out already, ready and waiting to go now that the application process is launched. So yeah, it is up to 12 weeks because we're asking for a lot of evidence. There are a lot of criterion to assess, and there are different stages to that assessment.
Okay.
So I think probably until we've estimated how long we think reasonably it's going to take, and we need to be able to provide all the information for Secretary of State to be able to make that ultimate decision. So there are processes to go through.
Yeah. Okay. Thank you for that. Well, it's always helpful for everyone to make sure they complete the poll question to get a nice little sense of the hundreds who are represented, the authority, all the hundreds of authorities that are represented on this, and also other organisations as well, to see what that influx of applications is going to look like. So
yes, please.
Yeah, please do.
That would be very helpful.
Yeah, it will make for a nice summer for you, Jane. Yeah, working for you.
Yes. Although it's absolutely pouring with rain here at the moment. I just looked out the window. It's where I am in the southwest, so it's summer in inverted commas, I think, at the moment.
Brilliant. Okay, just see if there's any others we want to sort of quickly highlight up here. Do you have a thinking about how much? I mean, I suppose these are going to be slightly different. These are going to be slightly different. Have you got an understanding about how much you think it's going to cost an organisation to set up as a responsible body?
No, we don't. In all fairness, we haven't done any sort of impact assessment on the costs of that, and the reason for that is it's not being prescribed, so it's voluntary. So the government isn't imposing this on any organisation. So we wouldn't normally do an impact assessment. It's an optional thing.
Mm-hmm. Okay. I'm sure there'll be some quick learning done from between authorities as they go through this, as there often is with new things that go on. So, okay. Sorry, just I mean, there's a question here we've got, and I think you've probably answered this already, but can a separate but linked commercial arm of a local authority be set up as a responsible body? So they can't do it on themselves, even if they're done as a separate body. That's not the process it's going to be laid out as.
I mean, I don't know what you think, Jane. If they're a separate entity and they're making their own application to become a responsible body and they meet the criteria, then yes.
And then could they then hold covenant in their own area?
Possibly. You mean so someone else is the landowner, but they're sort of related bodies, if you see what I mean. I think you need to be a bit careful, because obviously one of the things that we're setting out in the criteria is that any conflicts of interest need to be explained, and any future conflicts of interest need to be noted, and we need to be told about. So in those situations, you'd have to be careful, I think, that there wasn't an immediate conflict of interest between the responsible body's functions, because they are a sort of subsidiary or a part of another responsible body who is the landowner, if that makes any sense. So you need to keep an eye on what potential conflicts of interest might exist in those circumstances.
Yeah, okay. Yeah, yeah. I suppose that, yeah, yes, okay. Becky, have you got any in particular you've highlighted coming through as you're looking through as well? I see you've come on screen.
Yeah, I was just going to bring up the point about enforcement, actually, and this specifically relates to biodiversity net gain. So I think there's been quite a few queries around if the responsible body doesn't have an enforcement role, where does that role sit when you're talking about biodiversity net gain? So for conservation covenants more broadly, that might not be an issue, but obviously because of the planning element of biodiversity net gain, there's a bit of a question around that. So I think if that's not something that's clear now, it's probably something that will need to be thought about through the guidance that's coming out, because I think there is going to be some enforcement guidance, isn't there, on BNG? So yeah, I don't know, Katie or Anna, if you've got any answers on that one.
Yeah, we will be producing guidance which will include information on enforcement. And although what Tim said, you can still set out, well, correct me if I'm wrong, Tim, but you can still set out enforcement protocols within the conservation covenants. So for BNG, they still would have the same level of enforcement as the Section 106. Yeah, I've got some notes. Okay.
Yeah, no, absolutely. Yeah. So you can agree how the responsible body would enforce. The point I'm making is that they don't automatically get powers of enforcement.
Yeah.
So within the agreement, it would be very wise to agree how the responsible body will monitor and enforce, inverted commas, the agreement. Absolutely. Yeah.
And that will be in our guidance to say you should set this out. So yeah. Hopefully that covers that worry.
Brilliant. No, that's really good. I think there was just a bit of a lack of clarity there. So there was a few sort of questions around that. So no, that's good.
Thanks,
excellent. I was just going to come in actually on the point around, because we get this query quite a lot about Section 106 and whether a local authority can have a Section 106 with themselves. And I think, I mean, local authorities do that sometimes when they've got, but again, they have to obviously go through that due diligence and process. And I think it's where they've got a sort of separate arm set up, and those obviously have to be very separate. So I think they're where the local authorities are used to doing that. I suspect they may be able to fulfill, just off the top of my head, they may be able to fulfill the requirements because they'll be used to doing legal agreements across, so I would imagine without any kind of legal background at all, but I would imagine it would be similar because it's a legal agreement. But yeah, I think it will depend on the local authority and whether they're happy to do that. So I know some local authorities are very much not happy to have that situation and others are. So I've heard different, for BNG, I've heard different approaches taken. So I suspect it might be the same.
And I think someone in the chat put about using a lease model as well, potentially with the Section 106 is another solution.
Chris has just brought up another question actually in the chat around the enforcement side of things and whether you can put a commuted sum in the conservation covenant, which you can't do in Section 106 for enforcement. I mean, I'm guessing given their flexibility, you can add in, fees for whatever is in the agreement. But I don't know, Katie or Tim.
I'm nodding, but I'll look to Tim.
Well, I'll be honest. I'm not sure what I'm not sure that I understand what a commuted sum is, but certainly covenants can include sort of schedules of payments. I'm not familiar with the commuted sum under Section 106. I'm not a planning person, so I don't want to put you on a spot, Katie. Are you familiar with that, or we might have to take that one away?
Yeah, we might have to take that away and just check in terms of legal advice as well. But yeah, my understanding is you can get that payment through conservation covenant, but we will just double check that and get back to you.
I mean, I would suspect, Chris, that you wouldn't be able to say it was a sum for enforcement, because presumably whoever's signing the agreement would be like, well, you're not going to need to enforce it because I'm going to do it really well. So it would be a sum for monitoring that would encompass any enforcement that was required, because obviously, someone's not going to assume that they need to be enforced. Hopefully you wouldn't sign up to the agreement if they did.
But you would be building in a management cost, wouldn't you, into the covenant anyway, and I'd suggest that that's part of the management cost that would be worked into the process bit, probably without calling it an enforcement commuted sum, I suppose, to go through. Okay. I don't know that one.
There's one about legal costs there, Steve, I'll pick up on.
Yeah.
It's for the signatories to the covenant to cover the legal costs. So there is no sort of supporting financing for developing covenants. I don't know whether a BNG does the developer cough up for that?
Yeah, for BNG, you would price that in your unit price. So obviously it's an income stream for landowners, so they could pass all the costs on to the developer.
We've got a question here regarding if a conservation NGO enters into a conservation covenant as a responsible body, can they carry out that work on behalf of the landowner in addition to their other duties?
Say that again, Steve.
So if there's an NGO, a conservation, working in an area, can they enter into can they become a responsible body and enter a conservation covenant if they are working in that area?
No, no, it's the short answer. I'm hesitating slightly because it could be within the agreement that they have, you identify them as supporting delivery of the covenant in some way, but the covenant can only be between the responsible body and the landowner. So even if they were also designated as a responsible body, in those instances they wouldn't be the responsible body, if you see what I mean. Yeah, so the covenant can only be between the landowner and the responsible body.
So recognizing who's working within that area, recognizing that the responsible body could be a partner of the responsible body, is that right? But they
and I think
there'd have to be another body leading on that as part.
And it could be that the responsible body is relying on them to provide the expertise, for instance, to monitor and inspect, which is fine. But if legally the relationship is between the landowner and the responsible body.
Graham, are you nodding to this as you thinking that you've thought through this bit already? Is that?
All I was thinking was if it was something like a wildlife trust and they were a responsible body, you could have two responsible bodies within that one conservation covenant, and you could take on the role of, say, monitoring or supporting one aspect of it specifically.
Yeah, it's an interesting point, Graham. We might need to take that away because we've considered the model where there might be multiple landowners, but we probably still have an outstanding question whether there could be multiple responsible bodies in that sense. So I've just signed a note of caution. I think it's probably right, but I will take that away as the question we need to answer, I think.
Okay, great. Yeah, I'm sure there'll be lots of authorities who will be sitting thinking about this and trying to work through the processes, thinking about their areas and the requirements that they're going to have within their own development areas. And local authorities are very good at sharing their thinking. And so as they go through this, and I think someone's just posted up in the chat actually, I'm sure there'll be lots of people sharing their thinking through the PAS BNG practitioners network about how they're thinking about going through this to kind of learn from each other as they go. So, okay.
I've just got a couple of questions to just bring up, which are kind of around, I guess, the benefits of these versus other agreements. So there's a couple of questions around Section 39 agreements, which are under the Wildlife and Countryside Act, and how these might be conservation covenants be better than those. And is it just because they allow the conservation covenant goes with the title of the land? And I know that in Warwickshire, for example, they use those to secure BNG, but my understanding is it won't be possible to use those for BNG going forward. I don't know if anyone's got any thoughts on that one, or whether that's one to take away as well on those Section 39 agreements. I think my memory vaguely is that those were covered in the sort of initial paper that came from the Law Commission around conservation covenants.
Yeah, I think the Law Commission was pre-Environment Act, obviously, so that recommendation wasn't taken forward, is my understanding, but this isn't my area, so I can also pick this up with the relevant team and get back to you on section 39. So yeah, that's my understanding.
There was another one that I was going to raise around that, but I've now lost it. But yeah, sorry, did anyone else want to come in on that one? Oh yeah, no, there was just a question about whether you have to say, are you doing this for conservation or heritage separately, or are you, or can you, do you have to tick one box or the other?
You could, do you want to answer that, Jane? You can.
Well, when you say doing that, is that applying? Do you mean, Becky?
Yeah.
If you're applying, we do ask, yes, for you to state the type of conservation covenants that you expect to enter into, and then you'll need to have expertise to be sufficient expertise and provide evidence against that, to enter into conservation covenants for nature or for heritage. I don't think in theory there's anything stopping a responsible body being a responsible body for both, but that would involve quite a lot of expertise in two separate areas. So I'm not quite sure if that would be a sort of a robust application.
Yeah,
I mean, I would imagine
right.
local authorities would, because they would cover both those things. So I think that's probably a question, yeah, that would come.
Yeah, I mean, I think Becky, Jane's right. Theoretically, if bodies have both of those, can fill. The bottom line is if they can fulfill the criteria for both, then they can become a responsible body and implement both kinds of covenant. And these covenants, just to be clear, can have nature conservation and heritage as one of their purposes. You know, it could be a mix in theory.
Yeah.
So just thinking about that, once the conservation covenant has been set for a land, there's a question here about, does that effectively become a part of a planning designation then? So that would that cover the requirement on the land forthwith?
I mean, in effect, and others jump in, it's a deed, so it's on the local land charges, and it takes the form and effect of a deed. So I'm not quite sure that answers the question, Steve. No.
So if it's on the land, yeah, so it would still be, it would have to be considered in the, whilst if an application came forward on the land going forward, in the same way any covenant does already, any deed on the land does already. So yes. In principle, yes, it does become, it's given weight within the planning system. There you go. Okay.
I was just going to highlight in the chat, because that won't come through on the recording. There's a bit of chat around whether a local authority can have a section 106 with themselves, and most people are saying no, they can't. I have heard of some local authorities that are doing that for BNG. I can't off the top of my head remember who they are, but I will try and find out for folk on the network. So, but I don't think I've completely made that up. I did only just get back from leave for 2 weeks yesterday, so I may have just, you know, made something completely different up. But yeah, I'll try and find out for those folk on the network where on earth I got that one from.
My understanding was you have to have it set up as a separate body. Yes. With other partners, but you can be part of that partnership as a local authority to have an agreement, a section 106 agreement. Yeah.
So I think this is where you've set up perhaps as a habitat bank. So it may be Plymouth that's doing it, but I may be talking completely wrongly in that sense. So
well, I'm just really glad we're recording this, Becky. So that's
yeah, I know. I'm just going to say I won't mention any other names.
Okay, fantastic. Okay, I mean, I just want to to reiterate to everybody about the filling out the poll surveys as well, because it is really helpful just to get that sense about where we think the demand will be coming from here, but also kind of from what you've heard as well about, you know, whether what information you might need to be able to help you to be able to make decisions to move forward as well, I suppose. And there's an opportunity within that as well about just to kind of highlight some of the kind of key takeaway bits that you might have there, and if you've got any kind of separate questions. So we will go all of the questions from the Slido and the FAQ and things like that are going to be, from the Slido will be produced into the sort of FAQ, and we'll have a little look through the chat function as well, just to say, because we've tried to keep it all into one place, if you like, as we're doing this. So just as we kind of think about time, is there anything particularly you want to kind of particularly answer at the moment, Tim, Jane, rest of the team, or particularly kind of give us a sort of a comment to organisations that are thinking about it at the moment?
I haven't got much to add, but I need to say thanks very much for everybody joining the call. The questions are incredibly useful for us because, as Jane said, they're a new tool, covenants, so they're going to be novel for a while, and in some areas, relating to things like new green markets, that's all fairly new too. So yeah, just incredibly grateful for people joining us in asking some great questions. I don't know if Katie, Jane, Anna, you want to add anything to that?
Yeah, I was going to say the same. I think we've already thought about the questions that we won't have time to answer or that we need to take away. We can use those today to develop some sort of Q&A for most asked questions. So that's really helpful for us because it is a new policy area. So we don't have all the answers, but we'll certainly try and get them.
Yeah, definitely. Just to reiterate, thanks. And I see a couple of questions around reporting as well for LPAs, and I will come back to them. My understanding is that the sum of all the game plans will suffice for biodiversity reporting, but again, it's not my area, so I will get back to you on that question because I can see that was raised a few times.
Brilliant, thank you. And I'm just going to come in, as I'm aware that the chat isn't going to be recorded, just to say that Penny Simpson and Richard Broadbent from Freeds, who are lawyers, have come back and said, yes, local authorities are setting up habitat banking vehicles, which are a separate entity in order to have Section 106s with them themselves. So I was sort of talking, I wasn't using the right acronyms and things, but I was sort of making some vague sense. So yeah, I just want to get that out there.
On the recording that you were right.
Yes, exactly.
Graham, do you want to come in?
Can I just come in? There's a few questions around Natural England's intentions which we haven't addressed. I'm going to pick on one of them, which I think might cover a few of the points. Why do we need responsible bodies of Natural England as SNCO? I'm not sure what SNCO means, or becoming one. It's not Natural England's intention to sign up lots and lots of conservation covenants. When we've discussed it, we've always seen it as being using this tool in a limited number of situations where a conservation covenant works better than the existing tools that are available to us. So we're not going out looking for extra things to do. We're looking at being able to do what we already do using a more appropriate tool because a conservation covenant is better. So I think that probably says we wouldn't be a backstop. We're not trying to be a backstop. If conservation covenants are to be used across the country for anything, there needs to be lots and lots of responsible bodies out there.
Yeah, thanks, Graham. I hope something I said earlier doesn't suggest that if there's nobody else, Natural England are going to be there. So no,
it's very much that it's two parties, and two parties must have a benefit before they sign an agreement. And that applies to any responsible body as much as Natural England. Both parties must want to enter that for it to work. Yeah,
okay, thank you for that, Graham. Okay, in which case, I think I'm going to sort of slightly call this to a close, if that's okay. There's lots of kind of really interesting questions. There's lots of questions, and we say we will sort of take the time a bit to try and go through those as well. Anna, do you want to come in there?
Thanks, Steve, and thanks, everyone. Really interesting questions. I've been a bit of a fly on the wall, but yeah, really interesting discussion. Just wanted to plug a few webinars we have coming up, specifically on biodiversity net gain for the supply side. So if anyone's interested in selling biodiversity units in the off-site market, I will put the links in the chat. So we've got one basically straight after this webinar, if you fancy a back-to-back, starting at 3:30, and it's quite a high-level view of how you can get involved with the off-site market. And then we've also got one coming up on the 7th of August, which is about how you use a biodiversity metric to baseline your land and work out how many units you can sell. So that's also relevant to ecologists working on the supply side. So yeah, just wanted to bring those up in case relevant to anyone on the call.
Okay,
Thanks.
brilliant. And Anna, if you post those up into the chat, I'll make sure they get added into the email that will go out. It might not be in time for 3:30, but we'll definitely do our best for the end of the day, if that's okay.
Amazing. Thank you.
Okay, in which case I'm going to give final word to Tim, actually, if that's okay, since we're hosting this for Defra. So.
No, thanks, Steve. I mean, very little to say, really. Just thanks again for everybody attending. Have a look at those email addresses if you have specific queries, and try and respect where the queries should go, i.e. the BNG team or us. We're very happy to take those queries on via email. And also, just as a final point, we are keen that people apply. So do have a look at the guidance, do think a bit more, and hopefully the poll at the end will give us a clue as to how many people are already thinking about it. But yeah, please do look at the guidance and have a think about applying. And that's it, really. Thanks, Steve. And thanks again to PAS, as ever, wonderfully organised, very helpful. So grateful to you guys. Thanks.
Well, thanks, Tim. I mean, these things only work if people kind of contribute, and there's obviously a lot of contributions going into this as we go. So I say, please do make sure you take a look at the polls that are there. It's that stuff which is really a helpful kind of place just to be able to capture information from you as you go as well. And it will help to help to think about how we might even be able to think about this going forward as well, to be able to help authorities going on. So in which case, I'm going to let you go have a little break. Those of you who are in for back-to-back sessions for 3:30 have got a little opportunity to get a bit of a coffee and a break. So thank you all very much. Have a good rest of your afternoon, and enjoy this hopeful sunshine eventually.
Thank you, everyone.
Thanks all.
Thank you.
Bye.
Bye all.